Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh to Madam Asna Lisa and to all my fellow classmates. Today we are from Group 1 will present about squatters' right in Malaysia. Before that, let me introduce myself. My name is Nofara Amirah binti Hasdi. My group member consists of 8 members including myself, which is the first one is Alani American, Amira Shazrin, Amira Shaira, Darwishah, Adlia, Nuri and also Sohaila. Okay, next I will pass to the next presenter or to the first presenter, which is Amira Shaira. She will give some briefing or definition of squatters in Malaysia.
Okay, hi, Assalamualaikum. My name is Amira Shaira binti Zulkifli. My TIN number is DIF 201016. So, today I'm going to explain what are the meanings of the squatters. So, what is squatters? Squatters is, according to the Cambridge Dictionary, squatters means a person who live in an empty building without a permission, where someone in the past who took the land that did not officially belong to them in the first place, and they use it for the farming. The other words of the meaning of the squatters is a person who unlawfully occupies an unused land or unused building. And then other than that, the meaning of the squatters is a person who occupies a real property without the claim of rights or the title. And then the squatters also means that someone who lives on the land without permission from the owner. So when someone who live on the building or the others lands without the permission of the actual owner, they being called as a squatters. Now I will explain the cases and example cases of the squatters, which is the case of Bukit Lenang Development Sdn Bhd against penduduk-penduduk atas tanah in Johor Bahru. So I will explain a bit facts about this case, where the plaintiff entered an agreement sale and purchases with the outfit enterprise to get a piece of land, to get a piece of lots of lands. So the said land was occupied by an unknown people, and the defendants who unlawfully stay at that land. So the office Sdn Bhd ni then obtained a court order to remove the people, which is the defendants who trespass their land, and they the Auckland Sdn Bhd ni also get the writ of possession from the court, and the writ possession was obtained. Unfortunately, the attempt to remove all the trespassers, which is the defendant, was unsuccessfully. And then the plaintiff proceed with the application under the section 89 of the Code of Rules, where both plaintiff and the outfit never give the authority or never give the permission towards the defendants to stay or live at that land. And then the court held that there was no evidence that the outfield Sdn Bhd ni give the defendants permission to stay at that land. And then a person who enters upon the judges said that in this case, a person who enters upon another's land and remains to the detriment, which is where the person affect the real owner of that land, is being called as a trespassers. So the court find that the defendants were squatters and do not have any rights toward that lands. So when plaintiff become the registered proprietor, the defendant became a trespassers. And then the final decision of this in this case is the defendant failed to claim the existence of any issue regarding that land, as well as the section of as well as in the section 89 of the Code of Rules was correctly applied to the plaintiff. So the defendant has no right to claim for that land because they entered the land without the permission or any title from the real owner of that land. So the meaning of the squatters was interpreted in these cases where the squatters means a person who comes to the other's land without the permission or without the title from the owner of the land. So I think that's all for me. I will pass to the next presenter. Thank you.
Hi and Assalamualaikum. My name is Alani American binti Izzuddin American. My metric number is DIL 201004. And today I'll be talking about the definition of possession, what is adverse possession, and adverse possession of land in Malaysia. So, what exactly is possession? Possession is a term that refers to a person's physical relationship of control over something. Salmon defined possession as the continued exercise of a claim to the exclusive use of a thing. Main define possession as a physical detention combined with the intention to claim the object detained as one's own. In the case of superintendence and remembrance R, the Supreme Court stated that possession is a polyamorous term that may have different meanings in different contexts. So therefore, it is impossible to devise a completely logical definition of a possession that is uniformly applicable to all situations and statutes. So moving on to adverse possession. What is adverse possession? So basically, adverse possession is when someone stays long enough in a piece of property that is not their own that they end up owning it. So that is like the basic concept of adverse possession. Those who live on or in the possession of another person's land are said to have adverse possession, which is a legal principle that grants them the title to the land. The title to the property is given to the person who owns it as long as certain conditions are met, such as whether they infringe on the rights of a real owner and whether they have been in continuous possession of the property. Adverse possession is sometimes called squatter's right. Squatter's right are just a term for the idea but not a specific law. Adverse possession means that one party is given the right to another person's property because they take the possession of it, intentionally or not. This can happen to the owner's property whether he or she give their permission or not. People who intentionally take someone else's land, like trespassers or squatters, knows that they are taking someone else's land illegally, and they still choose to live on it because they just simply do not care, basically. However, in some cases, someone may not mean to take someone else's land. For example, when the homeowners build a fence to separate their yard, they may not realize that they have crossed over and encroached on their neighbor's land. The decisor or the person who doesn't own the property can claim in either case, and if the claimant can show that they have been in the land for a very long time, they do not have to pay the owner for it. Moving on to the adverse possession of land in Malaysia. Malaysia does not recognize the concept of adverse possession. In order to take back the squatter's occupied property, owners can use Order 89 of the Rules of Court 2012, which allow them to do so through a writ of possession. However, in Malaysia, the idea of taking someone else's property is not new. Before Malaysia was formed, each state has its own set of rules, tradition, and custom about how people could live on land. In general, the law says that there are two types of land. The first one is the wasteland or tanah mati that doesn't show anyone has been farming in it. As there are no signs of farming, no one can claim to own the land. Next, land that has been turned into a rice field or tanah hidup. Anyone who cultivates the land will end up owning the land. King or the state still own all the lands, but they let people turn wasteland into a living land as long as they pay a tenth of what they made from the land to the king or the state. These rules were put into place during British occupation, and the National Land Code 1965, or also called the Code, made them official. The torrent system, which was first used in South Australia in 1858 and named after Sir Robert Torrens, made it easier to keep track of ownership, title, and interest. So in conclusion, in Malaysia, squatters have no legal or equitable rights. Despite the fact that this is a serious problem that has the support from the general public, no action can be taken until Parliament change the law governing to the squatters' right. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh to Madam Asna and to all my fellow classmates. My name is Nofar Amirah binti Hasdi, metric number DIL 201009. So for my part, I will explain about do squatters have any rights in Malaysia? Before that, we need to know what does it mean by squatters. So squatters are people who unlawfully occupy, settles on property without right or title or any payment for rent, an inhabited building or unused land. So we go back to my question. Do you think squatters in Malaysia have any rights? Well, the answer is no. Okay, because of what? They do not have any right whenever they simply move into the property or land, and they do not have any right to move into the land or property, which could be considered in law it's crime. Okay, or in thought we call it as trespass to land. This happens when they breaking or entering or moving to other land illegally. So we have seen so many times in Malaysia, whenever folks find the houses are being abandoned, sometimes they simply move in and squatters there. So we can see in Malaysia, in the urban areas, for example, like in Kuala Lumpur, so there are some statistics that shown us the squatters according to states. So I will show you in the next slide. Furthermore, the reason why people in Malaysia cannot squatters easily because they do not have proper utilities. So we can see in the news in 2019, 5 rumah setinggan di Kampung Baru musnah dalam kebakaran. So we know that Kampung Baru is located at the urban areas of Kuala Lumpur, near the Chowkit. So whenever or some of us may know that Kampung Baru also have squatters, a lot of squatters. So this can give such a bad reputation because we know that Kuala Lumpur is the main attraction in Malaysia because main place to tourists come and visit our country. So we see in the news that 5 rumah setinggan Kampung Baru musnah dalam kebakaran. It shows that they do not have a good structure of house because their house was made by zinc, woods. We know that they cannot afford to live in the house that use in Malay we call it batu bata. So it's kind of like sad because we know that a lot of people also want to have a good shelter, but they do not have the opportunity to live in a comfortable place. Moreover, the squatters also will be given notice from authority to clear the place because it's clearly shown that they moving in the land, into the land, or they entering into the land illegally. If let's say they don't want to listen to the authority to move out or to clear the place or to moving out from the place, their house will be destroyed. Okay, next we may see from the pictures also, they don't have any proper place to throw their garbage. Can you imagine we as a human being have to live in that place that full of garbage, and also full of, we know that any harmful things, for example like maybe there is snake under the garbage or maybe there is dangerous rats. So this can be very dangerous to the children and also to the old people.
Hi and Assalamualaikum. My name is Tausha binti Alikuzaman and my matching number is TIL201005. So today I will present about section 48 of National Land Code and section 341 of National Land Code. So the first one is section 48 of NLC prescribe that no title to state land should be acquired by possessions, unlawful occupation or occupation under any permission for any amount of time. Therefore, after a long period of unlawful occupancy of state territory, the occupant will not be able to establish title to the land. Next, Section 341 of NLC specifically specifies that adverse possession of land for whatever amount of time should not constitute a bar to the bringing of any action for the recovery by the proprietor or any person or organization entitled to an interest therein.
Thank you, Darisha, for your explaining about the law applicable for this case. And for my part, I will explain more about the case of Siddiq bin Haji Muhammad and other against government of Perak in 1982. So before we get started, I will introduce myself first. My name is Nurul Amira Shahzri bin Nasiruddin and my metro number DIL 201010. So without further delay, let's get started and I will explain more about the fact of the case. In 1950, the appellant who were from Kedah, North Perak and Selangor came to the Teluk Anson and opened up a jungle area. The appellant was squatters as more and more squatters come to settle in the area. The state government reorganized the settlement, which resulted in the new settlers being placed in the land where the appellant were already in occupation. It was alleged by the appellant that the district officer promised each settler family will be given 3 acres of a paddy land subject to successful interviews. There were also articles in Utusan Melayu quoting Bernama as the source, stating that the state director of the land and mines had said that each pioneer settler family will be given 5 acres of a paddy land. After interviews were held, the appellant were unsuccessful and were subsequently given a notice to stop work and to vacate the area. The appellant brought action seeking a court declaration inter alia that they are entitled in law and in equity to be in a possession of the land originally pioneered, opened up, and occupied by them. The respondents added that the appellant claims were baseless as they were illegal occupiers of the state land and sought to strike out the appellant's action. The action was struck out by the High Court on the basis that the appellant were trespassed on the state land and that there can be no adverse possession of the state land. The appellant appeal to the federal court was dismissed on the ground that the appellant had no cause of action either in law or in equity as they were squatters. The federal court also cited the offense under Section 425 of the National Land Code and stressed that the only way to obtain state land is by way of making a formal application for land under the NLC. As regards the position of the squatters under the law, Justice Raju Azhar Shah in this case alluded to the right of a legal owner of the land to turn out such squatters without even going to court for an order of oppositions. This refers to the self-help remedy under the law of the torts. The learned judge observed as follows. First, it is well established that a court of equity will never assist squatters to resist an order of opposition illegally acquired. It will never intervene in aid of wrongdoers. We would like to see this at once about squatters. Furthermore, the owner is not obliged to go to the court to obtain an order of opposition. He is entitled, if he so wishes, to take the remedy into his own hands. He can go in himself and turn them out without the aid of the courts of law. He can even use a force so long as he uses no more force than is reasonably necessary. Finally, he will not then be liable either criminally or civilly. This, however, is not to be encouraged because of the disturbance that might follow, but the legality of it is beyond question.
Hi and Assalamualaikum to Madam and everyone. My name is Nuri Balkis binti Abdul Manan. My metric number is DIL201013. I'll proceed with my part, Remedies, Order 89 of the Rules of the Court 2012. Order 89 Rule 1 of the Rules of Court briefly states that where a person claims possession of land which he alleged is occupied solely by a person or persons not being a tenant or tenants holding over after the termination of the tenancy, who entered into or remained in occupation without his license or consent or that of any predecessor in title of his, the proceedings may be brought by originating summons in accordance with the provisions of this order. Furthermore, Order 89 applies to a person who has entered into possession of land with a license from the previous owner. However, that person, or known as squatter, has remained in occupation without a license from the present owner, and the previous owner cannot possibly have given an effective license to him to remain in occupation of the land after the previous owner had parted with that land in favour of the present owner. Order 89 of the Rules of High Court has always been read as applying to squatters. It does not apply to tenants who are holding over one who enters upon the land or who remains in occupation with the consent of the applicant under the order of any predecessor in title of such an applicant, or persons who are in occupation under a legitimate expectation of receiving from the state authority issue documents of title to the portion they occupy. Malaysia does not recognise the concept of adverse possession, which referring to the squatters, since they have no rights either in law or in equity. This matter can be referred through the case of Siddiq bin Haji Muhammad and others, and the government of the state of Perak and others, where the federal court dismissed the claims of the squatters and held that a person can only obtain a state land by way of formal application for land based on the rules and regulations which are set down in the code. That's all from me, and I'll pass to the next presenter. Thank you.
And Assalamualaikum. My name is Nosraila binti Abdul Hadi, and my metric number is DIL201014. Okay, so I will present my part. What is the best way to settle the problem? According to case law, squatters' trouble issue typically include having a secure express consent to occupy the land, which the majority of the time is a consent coming from the state government. In those cases, case history illustrate the court are witness to issue an order for possession under Order 89 of the ROC 2012. Preferring instead to allow party, the landowner and the unlawful occupier to argue the dispute point through a conflict trial. The rise in the number of squatters around the world is due to a variety of circumstances. Economic, social, and separately, religion aspects are the most visible. While the law is generally hostile to squatter rights and protection, this does not always mean that land and or property owners are free to exercise their rights. As a landowner, we have a responsibility to defend our ownership, legal interests, and legal title at all costs, and we must stay active and promote the effort, if necessary, to do so. This is especially true when it has come to our valuable land and or property, in which we have made significant investment. Squatters are those who live on our occupied land without having a legal claim to it. A squatter is a person who lives on land to which they have no legal ownership, title, or lease. Adversary transfer may be used by a squatter to gain who does not utilize or inspect the property for several years, thus losing the title to someone who makes a claim to the land, take control of it, and use it. In dispute cases, the burden of proof for upon the alleged squatters or trespassers to show that they had a license or consent of the owner to occupy the land. For example, suppose a woman named Ferencia bought a 2-bedroom investment in property 2010 in Brooklyn, New York. Stay empty for several months. Facing the foreclosure, Ferencia decided to put the apartment on the market. Unfortunately, she discovered that a taxi driver have been living in the apartment for a month. Policia called the police and report a stranger for trespassing. After the police removed the man, she has lost its chance. However, since the man had been living there for over 30 days, they had established a squatter right. Kicking him out of the apartment it constitutes an illegal evasion. When the squatter went to housing court in New York, the judge granted him permission to enter the property just a few days later. So that's all for my part. Thank you.
Thank you for the presenter. Now let's continue with my part. So before we continue, let me introduce my name. My name is Adla Kisna binti Mazli, while my metric number is DIL 201027. So I'm going to continue with the next part, which is the conclusion. So my topic is what are the actions that can be taken by the Malaysian government to deal with squatters. So basically there is 3 points. So let's continue with the first one. So the first one is the government should take the decisive action on the criteria and also to limit the property of purchases that can be applied by the squatters. So those who are currently own a home are prohibited from purchasing the another. So this is for me as an excellent decision that is not only keep the house price from skyrocketing, but it also allow most squatters to buy or rent government housing. So this restriction should be maintained for the sake of many parties. So in this way, the open opportunity can be accessed to those who has the low income. So it is not only for those who are given the opportunity to enjoy of many houses as they can afford. So the squatters cannot afford to purchase or rent a house in a situation when the price are too high, or maybe the number of house available is in the restricted. So when they're confronted with such circumstances, squatters can find their own way by illegally exploring government territory and also erecting their heights. So there is also like us that can be required as a suitable location to remain this residency of their children. So for the second point, the government should be given the employment opportunities to increase the squatters' income. So basically, if the income of them is remain stagnant for a long time, they will become a squatters. So the authorities should make an effort to assist the squatters make effort to assist the squatters in a certain area with a certain skill, which the squatters has the potential to thrive in their life. So in addition, those with specific experience may be involved in a specific area of business. So basically, a financial institution should be appointed to provide a loan to members of squatters' family that is for the undertake of a project or maybe a business that can improve their economic status. And they also must be given a stimulus opportunity that maybe can increase their income from the time to time. So for the last point, which is the third one, the government's systematic effort to relocate squatters should be welcome and also carried out. So basically, their relocation to a new settlement area has the potential to alter their standard for living and also attitude, with the latter resulting in an improvement in their respective living condition. So moving to a new settlement area that allow people to live is more order and also in the ideal environment. So in addition, the authorities need to prepare a special project for them, maybe to work on for them to generate more income. So basic services such as electricity, water, roads and others will be given in the new settlement area, and maybe their children can be receive a better education. So they will get a more mobility of opportunities in the future. So basically, a new placement will also solve many problems, and also one of them is the problem of crime in the squatters area. So this new settlement will provide an opportunity for the authorities to control and also to eradicate social ills and also in their area. So basically, that's all from me. Thank you.